the hobos get on. Whatever the fuck's going on down there. All right, we're going to get started in 5 seconds. Good morning, everybody. This is Omar Serrano with the Tilted Lawyer Podcast. So we're talking about the Delphi case, and they have gone to jury. Richard Allen's hands. His fate rests in the hands of the jury. And there's many opinions. There's been a lot of speculation that perhaps the defense team has bungled this. There's been many accusations that something stinks down there in Delphi. There's been many opinions that the judicial decisions, the judge's attitude towards the defense has unduly prejudiced Richard Allen and encumbered his ability to present a defense. However, the defense has presented evidence, and when we left off last week, prosecution had just rested. It was only a couple days ago that the defense similarly rested. Closing arguments have been rendered. Jury instructions have been rendered. The case sits with the jury. There can be a verdict at any minute. There was an odd request the other day that the jury wanted to end deliberations early. What does that mean? What does it mean? It can mean a number of different things. In my opinion, I think that this is headed for an acquittal. And the longer that the jury sits deliberating, the longer this goes on, the higher the likelihood that this case is going to end in an acquittal. Maybe a mistrial, hopefully not a mistrial. There's significant holes in the people's case. I'm going to break it all down as far as what the defense presented in their case in chief. I'm going to talk about the strengths and weaknesses of both sides. And then at the end, I'm going to poll all of you and simply ask you the question: has the state done enough to overcome reasonable doubts in this case? And if the jury convicts Richard Allen, if they don't convict Richard Allen, do you believe that justice has been served for the victims in this case? There's a lot to talk about, so let's get started.
Whatever you might be going through and wherever you might be, this is Omar Serrano with the Tilted Lawyer Podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
All right, folks. So we sort of left off on day 14 of trial last time. I'm going to briefly recap some of... Now, look, this is the big mystery trial, right? The judge has made certain decisions that has dictated that none of you get to hear exactly what's going on. We've had to rely on the recitations of journalists and famous LawTube YouTubers, Andrea Burkhart, Lawyer Lee, and others, for their impressions about how this trial has progressed. And we have some indications based on their notes and based on their observations. What we'll never be able to see is how all of this has played out. Although I trust the observations of Andrea Burkhart the most. She's a trial attorney. She's been in hundreds of trials. And so her impressions of the jury, to me, are very telling. And the tale that she has painted thus far, based on her own observations, watching the jurors' reactions to various bits of evidence, is one that it appears that this jury has significant questions with respect to the state's case. I imagine that they stem from why there hasn't been any alternate suspects offered. Now, look, we can only get so far into that, right? Because the judge made the decision very early on, no third-party culpability evidence. And then we thought that the door had been opened by testimony coming in of Weber and the white van. Turns out that they've known about that. People have been talking about the white van on Reddit for years. The state didn't introduce that evidence for, I think, when they were prepping for trial, which would have been years after the fact. Despite that evidence, the fact that they weren't able to introduce the possibility of additional suspects is alarming. The case law dictates that there has to be some kind of direct connection to other suspects. The problem with the judge's decision is, and let's just say that Richard Allen is convicted. The problem with the judge's decision is going to be that connection does not have to be like smoking gun evidence. It just has to be some tangential piece of evidence that connects person B to something relevant to the case. We've seen, and it's been instructive in the case of Sarah Boone, that it really just requires a small indicia of evidence to be able to open the door to those kinds of things. And the point is, you're putting a guy on trial for the rest of his life. He's literally fighting for his life. And so better to err on the side of evidence than to exclude things that might be brought up on appeal. The fact that the state hasn't been, or that the defense hasn't been allowed to introduce other suspects as viable possibilities is a bold move on the part of the judge. It leaves her subject to appellate scrutiny, is what I'd say. Even if you're of the opinion that Richard Allen is guilty, you believe the confessions or whatnot, that's fine. Then you should be of the opinion that we want all the evidence to come in, that we don't want to have any possibility post-conviction of appellate review overturning the conviction, because if you believe that Richard Allen is the guy, then justice is being served with his conviction, and now it gets thrown out because the judge made a poor decision evaluating the evidence in a way that is rendered by a future appellate court to have been deemed this an unfair trial in violation of Mr. Allen's constitutional rights. That's a big risk, and most judges err on the other side of that argument. So there's that. This trial is in jeopardy. Maybe. I know that there's a couple of witnesses that the defense wanted to get in before they closed and rested their case that they weren't able to get in, was what it was. On day 15 of trial, that was when the prosecution rested. The prosecution gives this unconvincing explanation about how they obtained evidence about the white van. They didn't even have the white van evidence or present it to the defense as anything that was going to be a thing until a couple of months before the trial. On day 15, they had discussed Richard Allen's mental state, which was highly relevant because it goes strictly to his confessions that were offered in this case. And the second that the state witness brought up the Reed technique, then his mental state was thrown directly under the spotlight. And on day 20, the jury had the opportunity to review a lot of video that was not disclosed, obviously, to the public. So I don't know what the contents were, but according to people that were in the courtroom, the jurors were sitting there with like their mouths agape. Like, what the fuck? Like, what is this guy on? They were just, whatever they were seeing led them to believe that Richard Allen was in a mental state that was not becoming of a guy that was had all of his marbles. And if you're of the opinion that he didn't have all of his marbles, and the defense, by all accounts, has seemingly done a good job in poking holes in the credibility of that confession, then what hope does the state have to get a conviction beyond reasonable doubt in this case? If that was the main indicator of guilt, according to them, there was not any other strong evidence that tied Allen to the case. From what we saw, from what was produced, There was not a DNA link. There was not a physical evidence link. There wasn't really any even circumstantial evidence because the Google logs and the cell phone data were inconclusive at best. All you had was this confession. And what the prosecution failed to do, as I harped on over and over again last week, was provide any evidence whatsoever that Alan gave details in his confession that were not known to anybody else, that would have only been known to the killer. Their example of that was the white van. Turns out people had been talking about the white van for years on Reddit. And then come to find out that the person that he gave that confession to happened to be a true crime junkie and was probably well invested into the details of this Delphi case. Did she plant evidence in his mind unknowingly because she was so knowledgeable about what she read on Reddit, on YouTube, or otherwise? And how, if you know that, does that impact your ability to find that it was a good confession? They played a video call of Richard Allen talking to his wife. And from what I gathered, it just seemed like this unhinged phone call. We got certain excerpts. Of course, we don't have the exact transcripts, but it was sort of like the impression seems to have been, if you were in the courtroom, that he seems like a guy that was just riddled with anxiety and exhaustion and fear and apathy. And so he says that, God, I know I must have done it. I hope that the families could accept my apologies. I pray for the families. He's saying things that I'll see you in the next life. And his wife is like trying to console him. It's like, you didn't do this. And they're having this back and forth. Is that convincing to the jury? I don't know. That I don't know. The prosecution presents this phone call on day 15 in isolation. They don't provide sufficient context to the jury to understand the circumstances surrounding it, which is going to make it difficult for a jury to interpret what the call's meaning is supposed to actually be. The defense correctly argues, as you would, that they're cherry-picking bits of the phone call to introduce the jury that is going to mislead the jury. There was strong indication as the prosecution rested that they lost a lot of credibility because of the gaping holes in their case. The way that they presented evidence, the way that they withheld evidence, the way that their investigators didn't follow up on certain leads. It seems to be the case that the defense did a masterful job of poking at that holes and opening them up really wide. Whether or not they capitalize that on cross-examination is up to anybody's interpretation. There seems to be a contradiction between style versus substance. Now, I'm a big believer, as a trial attorney myself, I'm a big believer in style. I oftentimes criticize attorneys for not having charisma, for not having a personality, for not being relatable to a jury. Style is important. But if you don't have any substance behind it, I don't know. It's troubling that was the comparison, style over substance. It seems like they're trying to go for this big home run. According to Andrea Burkhart and lawyer Lee, it looks like maybe they kind of fell flat. Maybe they didn't get what they were hoping to get. But you never know how that lands with the jury. You really don't. I mean, when I evaluate closing arguments, it's from the position of a guy that's had to argue in front of juries before. I have critiques. I've taught trial advocacy in law schools and tried to impart wisdom on law students on how to deliver a closing argument, what to do, what not to do. If you're trying to look like Matthew McConaughey and the Lincoln lawyer, it's not going to work out. You got to be yourself. You got to do this. You got to do that. You got to be believable. You got to have credibility. You can't be, you don't want to show up in like the $5,000 suit with the Rolex watch and the shiny shoes and sit there and, condescend to the jury. You got to humanize things for them. So style is really important. It affects, it's just like in cooking. In cooking, they say that texture is the conduit to flavor. If your texture is wrong and you want people to taste a certain thing, If you get the texture wrong, it's going to make it difficult for the jury. It just makes it harder. The delivery mechanism of the message is important. And so we have that. On day 16, it was a rough day for the defense. And it just leads me to believe, I don't know what's going on over there in that courtroom. I don't know what's up with the judge. I've been hearing for like a month now that this judge just has it out for the defense, that she's extra harsh with them, that she has been unfavorable to them on their objections, on objections against them, on restrictions on evidence. There's been lengthy sidebars that some have argued have limited their ability to present their case because it's taking up too much time. They weren't able to call in a couple of witnesses that they wanted to get in because the judge just refused to allow any evidence of third-party culpability. When you're trying to defend a client who's been accused of murder and you can't point to other witnesses, even though there are, however slight it might be, tie-ins to others, is really frustrating to do that. And now the focus has to be on, you have to question why. You have to get the jury to question why they focus so heavily on Richard Allen. But the answer to that is obvious. It's the confessions, right? So then if you're not able to point to any direct evidence that the investigator should have at least maybe followed up on, as introducing it as third-party culpability evidence, even if some of that gets in and it's not exactly clear what that's for, it might just fall on deaf ears. It puts your client in peril. 100% it does. 100% it does. So the defense they face on day 16 upon their opening case in chief, that the defense faced numerous objections from the prosecutions, frequent sidebars and interruptions. The judge seemed determined, according to some in the courtroom, to hurt the defense in any way that they could. Constant back and forth. Disruptions into the defense's presentation, into the rhythm. It's really hard. I don't know how many of you watching this show have ever had the opportunity to even give like a mock trial direct examination. Just ask questions to a witness. Not even a cross-exam, just get a witness to tell a story. You get into a cadence. It's like, all right, so what time did you wake up? And when you woke up, what did you do? And so you wanted to eat breakfast, what did you eat? Did you have all the ingredients? How did you prepare the food? And then what did you do? You're getting them to tell a story. If you got somebody constantly objecting to you, it messes with your rhythm. If you're not experienced, and I'm not saying that their attorneys weren't experienced, but it breaks up the story for the jury. They're getting annoyed probably, and they're constantly having to engage after being broken up by objections. It sucks. And it seems like that's what was happening to the defense in this case. The restrictions on evidence were just mind-boggling to me. So the judge makes several rulings limiting evidence. One notable example involved the use of a thumb drive that contained jail records. Defense wanted to demonstrate the chronological progression of Allen's mental decline during his incarceration, which seems pretty relevant, wouldn't you agree? I mean, if you get arrested for something and you're of the opinion that you didn't do something, and people are constantly trying to chide at you and interrogate you and berate you and convincing you that you're the guy that did this, and now you've been isolated into a maximum security prison, away from your family, away from your friends. I've heard people say, "Oh, we had an iPad to communicate with his family," and bullshit. He did. Maybe he did. Maybe he didn't. Well, actually, he did. It's not the same. It's not the same. I don't know how many of you have ever actually been inside of a jail cell. It sucks. It is the most deflating place that you could possibly stay. Like I've said many times, I've been doing these jail visits for years now. I've had many times where I've been able to go and talk to my clients as they sat in prison, just going to the attorney wing of the prison. You sit in this little box. And when you walk into the prison, they have to open the gate. Those doors are heavy. I'm talking about, I don't know how much one of those doors would weigh, but just imagine like a bank vault. When they shut, it's heavy, and you could hear them lock. If like, I always wonder, like, what if the power goes out? I'm just effing stuck in here. Is there even like a manual way to unlock the doors? And it probably is. But the point is, like, those doors are heavy. Those walls are heavy. You're talking about several feet worth of reinforced steel. The metal bars, the air is stale and heavy. You get claustrophobic. You're sitting there in this little 80 square foot cell with a mattress, a bed, and a toilet that may or may not have running water. If you don't have provisions for commissary, then you get your one meal a day, maybe, whatever it's going to be. And, you know, there's plenty of accounts out there about what prison food is like. It imposes on your soul the longer that you're there, and that's only being there for like an hour. Now, if you're staying there overnight, for weeks, for months, I think that it would be highly relevant for a jury to see the state that he was when he came in versus the state that he was in when he gave those confessions, because it matters. You think, right? The judge restricted the time frame that they could cover. Just restricted it. Why? I don't know. Deprives them of the opportunity to fully illustrate their points. Some have argued that it was a deliberate tactic by the judge to prevent the jury from seeing evidence that could damage the prosecution's case, because if you have, I can't think of a good reason why that wouldn't be relevant and probative of the issues. I couldn't think of a more illustrative bit of evidence to present video evidence of how Allen appeared at the beginning of his prison stay to how it ended up 13 months after the fact, leading to when he gave the confession. I just cannot think of a good legal reason why that is. And if you were to ask me in my own cases whether or not I'd be able to get that in, and you were sitting across from me at my desk during like a consultation, well, what about this evidence? How are we going to prove it? Could I get this evidence in of when he came in and when the... oh, absolutely. That's highly relevant. Of course I'm going to be able to get it in. I could not imagine a scenario where it would be limited in any way for a valid legal purpose. It's mind-boggling. And a huge red flag about the viability of this case going forward. If this case ends up in a conviction, I cannot imagine that there's not going to be a litany of appellate attorneys lining up and chomping at the bit to tear into this case and how it was tried and the judicial determinations that didn't allow for Richard Allen to get a fair trial and to present evidence that would have illustrated for the jury Richard Allen's defense, which means that this trial is at risk. If it's not a mistrial, if it gets overturned after the conviction, that means we're doing it again. And then what? If you're the family of the victims, I would think that you would want the judge to call a fair case, because not calling a fair case or calling a case that leaves her subject to appellate review is to necessarily withhold justice from the little girls in this case for an indefinite period of time. It's infuriating. Infuriating. If I was the father of one of these girls and I found out that the judge's misconduct has put the entire case at risk because her judicial determinations regarding evidence lacked actual judicial merit and could have been viewed as an abuse of discretion, I would be livid. I'm not even arguing guilt or innocence at this point about Allen. Not for this part of it anyway. I'm just saying, let's just say that he was guilty. Let's just say that he's the guy. Now you have a judge who has took it upon herself to encumber the defense, leaving her subject to an appellate review, putting the entire trial at risk, maybe leading to a retrying of the case, maybe leading to the state's decision not to retry Richard Allen, and leaving the victims, if you believe Richard Allen was the guy, without justice, and in your mind, in your beliefs, if you believe Allen was guilty, free to roam around after taking the lives of these two young girls because the judge didn't have her shit together. How would you feel? I know how I feel as an attorney. And I'm flabbergasted as a trial attorney that at some of the decisions that have been made, and I'm highlighting just the egregious ones. Moving on, there was some there was some successful impeachment testimony of Steve Mullen regarding his recollection of events. They highlighted inconsistencies in his testimony related to the timeline of his interactions with Richard Allen. It seems like that was effective. Mullen, he was a crucial witness for the prosecution. He was heavily involved in the investigation. And if you're listening to Burkhart and Lawyer Lee, they seem to be in accord that the defense was able to successfully impeach some of the inconsistencies, targeting some of his potential memory lapses, centered on the timeline of his interactions with Allen and the accuracy of certain details that was provided. But we've known for a long time that there wasn't really any hard-hitting eyewitness testimony that implicated Richard Allen. It was all just kind of fuzzy, you saw this guy covered in blood on a bridge. Well, maybe it was mud. Was he a 6'2" muscular, stocky guy, or was he a 5'4" kind of pudgy guy? Difficult to say. I mean, we've all seen Bridge Guy enough. I've seen varying opinions about what his physical dimensions would have been. I don't know, man. I know that doesn't look like Richard Allen right now. I'm well aware that he's been in maximum security prison for a significant amount of time. I know that he's lost a significant amount of weight. Doesn't change the fact that he's still 5'3", 5'4". He didn't look like a 5'3". It's difficult. We don't have like a physicist come in and say that, oh, based on this angle from the distance that the video would have been taken in relation to the other objects, according to this math, we have been able to properly deduce that this was a 6-foot-tall man. We don't have anything like that. Nothing like that came into evidence. I was expecting that it might. How hard would it have been to get like a mathematician, physicist come in to talk about, or like I don't know, whoever does that kind of a thing, coming to testify as to the specific dimensions of Bridge Guy. If I was a defense attorney, I feel like I would have paid for an expert witness to at least give their opinions of the dimensions, given the settings of the camera when it recorded the video, distances, whatever. It may or may not have been believable, but it would have at least been a measure to raise doubts. Especially knowing that you have an exceptionally small-ish client who stands 5'3", 5'4". I don't know his exact dimensions. I just know he's short. He's really, really short. And when I say short, he's like in the lower 90th percentile of all men. It would have, seems to me, have benefited the defense to have introduced a witness like that, an expert to just talk about those dimensions. There was impeachment testimony regarding the person that had prepared the sketch. The defense's strategy seems to be shifting throughout the trial towards highlighting the terrible conditions that Allen faced in prison, which tells me a couple of things. They're not all that concerned with the other testimony. There was not DNA. You don't have any physical evidence. You don't even have reliable eyewitness testimony. They have this confession. And so they spent a great deal of time highlighting the terrible conditions that Richard Allen found himself while he's been confined in this maximum security prison. Now, they argue that those conditions, combined with the administration of powerful antipsychotic drugs, led to his mental breakdown, false confessions. Has it been effective? Maybe. I think if you couple that along with some of the video evidence that came in, I suspect that the video evidence must have been visual demonstrations of his breakdown. And from accounts of people that were in the courtroom, the jurors had visceral reactions to seeing some of that. Mouth agape, hands on their face, that kind of a thing. By all accounts, It seems like day 16 was a day full of the defense constantly battling both the prosecution's objections and the judge's decisions with restricting evidence. And we've talked about that. It was a frustrating day. So on day 17, the focus was on video evidence. They started with video playback. And we're going to talk about some of the jurors' reactions. So it involved playing 8 different video recordings of Allen in his jail cell. So probably when he was at his very, very most depths of despair. It was played on a television position so the public couldn't view it. So obviously there's not specifics about what were contained, but what is documented is that it was observed that the jurors were sitting there, resting their hands on their face, making mouth movements, head shaking, yawning, which is an interesting one, touching their faces, mouths with slightly agape. You could argue that those reactions were because they were potentially witnessing some compelling or disturbing footage regarding Richard Allen's degrading mental states. That's an argument to make. Of course, we don't know. There was a lot of sidebars and evidentiary discussions on that day. And that was pretty much it. On day 18, the defense rests. They rest without calling a couple of witnesses that they had proffered. And those witnesses presumably would have been to introduce evidence about questions about why certain other individuals weren't investigated, I guess. And the judge wasn't going to allow it, so they rest. The state offers a rebuttal. I have heard that the state's rebuttal was kind of stupid. Andrea Burkhart described it as being ill-conceived. They focused on certain testimony that went towards the expert that was talking about Allen's mental state and his reliability in that mental state to give a good confession, highlighting, I guess the state thought it was a strength. Others thought that was some of the weakest testimony that highlighted how unreliable the confession was that they obtained. And so the rebuttal wasn't much of anything. The defense rests without calling Richard Allen to the stand. That was predictable. There was no benefit to calling Richard Allen in this case. That would have been the stupidest thing they could have done. Imagine you get that guy on the stand. What are you going to say? Hey, so you confessed to the murder, right? Yeah, I did. You didn't mean it when you confessed, did you? No, I didn't. Well, why did you do it? Well, because, and he's going to say whatever he was going to say. At this point, he becomes like a 12-year-old who's being defensive because he decided to ditch school that day and he got caught or whatever. There's no scenario where that plays out where he doesn't look guilty. And in the off chance that he might have been able to pull it off and come off as a sympathetic figure, there was no reason to in this case. I thought that, with what the experts have come out and say with regard to the Reed technique, with some of the other evidence of his mental degradation, there's no need to call him in. Plus, you're talking about a guy that was so mentally deteriorated that he's giving false confessions to murders that he didn't commit. And then you get him on the stand because now he's competent. Now on the eve of trial and all of the anxiety that comes along with it, now he's somehow clear-headed and able and stable to go forward on and face the extreme scrutiny of a cross-examination. And some would argue the trial of the century. I don't know. Certainly in Indiana it is. There was no optics that would have been beneficial to the defense. So, of course, he wasn't taking the stand. They talk about jury instructions. There was a lack of proposed jury instructions, which is upsetting in a criminal trial. So, jury instructions, I don't know how many of you have ever tried a criminal case, But the jury instructions are everything. You think it's a small detail, and look, younger attorneys will get in there and they'll be like, oh, well, they already got like sample jury instructions right here. These seem good enough. I could use those. But the way that these instructions are conveyed to a jury are extremely important. There's a boilerplate. There is a boilerplate way of describing murder. There is a boilerplate way of describing confessions and false confessions and your impressions of those confessions and how evidence has been presented and how the jury is supposed to interpret evidence. You want to propose, even if there's boilerplate stuff, yeah, take that and you craft the language to be more beneficial to your side. It's what you do. It's one of the key arguments that occurs in these criminal trials between defense attorney and prosecution. It could literally cost you a case if the jury interprets jury instructions a certain way, in a way that you didn't anticipate, and then they say, well, if this is what that means, then I have to vote this way, even if I feel a different way. So you got to be very careful with jury instructions. It is a very underrated variable when it comes to these criminal trials. So the day concludes, day 18. There's lots of anticipation, lots of uncertainty, a lot of questions hanging in the balance. On day 20, closing arguments, and the juries begin deliberation. Now, interestingly, the jury departs early during deliberations, and people have been speculating what that meant. So the jury begins their deliberation. They're tasked with meticulously reviewing the evidence, and you're talking about a 20-day trial. Witnesses and evidence in 3 weeks, and they're tired and they're sick of this, and they haven't seen their families, and they haven't, been able to look at the internet or whatever. They're tired. They haven't been able to go to work. They're worrying about their own lives, and they're exhausted. They must be. They request to conclude deliberations the day earlier at approximately 3:20 p.m. on day 20. Which would have been about 40 minutes prior to the judge planning to release them. He was going to release them at 4 anyway. They just wanted to go home. What does that mean? What does it mean? In my estimation, in my experience, I feel like this was it. The jury's exhausted. They're tired. They're getting into portions of evidence that they don't agree on, and they don't feel like talking about it today. They just need the night to process their own thoughts and come back fresh, knowing that they're going to deliberate in the morning. Doesn't mean good or bad for either side. No, not really. Because I'll tell you what, if they took like a poll of jurors and it was like 11-1 in favor of guilt, they wouldn't have concluded early. It's probably something like 6-6 or maybe 4-8 in favor of acquittal or whatever. But it wouldn't have been inevitable that another 40 minutes would have produced a result. They probably talked about portions of evidence that they wanted to revisit. They probably wanted readbacks from some of the expert witnesses, maybe, probably related to mental degradation and its effect on producing false confessions. They probably just had a lot that they weren't going to finish today. And you're like, you know what? Fuck it. We'll just do it tomorrow. Can we just do it tomorrow? Tired. I need a nap. Perhaps a spa day or something. I don't know. It's just probably a lot of fatigue, emotional strain. Maybe they're getting on each other's nerves. Maybe they just don't like each other. Maybe they're sick of each other. That happens on juries. It really does. It's funny, some verdicts that I've been on, you could always tell. Well, I don't know if you could always tell. I feel like I can tell. The jurors that were holdouts for a particular verdict that ended up flipping. The ones that were in favor of one verdict or the other, and it's their verdict, for example, you saw it in the Sarah Boone case. They're polling the jurors about, is this your verdict? Yes. The guy's just yelling out. He couldn't get it out fast enough. He was so pissed. And you'll see other jurors like, yeah, kind of meekly just saying, yeah. And so, look, I feel like jurors take their jobs seriously. And there were some that were convinced from day one or two about the guilt or innocence of Richard Allen, because the prosecution gets to go first, and there are others that really want to just run through an entire 20 days, and the prospect of doing that was just a bit much for that day, so they has to be left alone. So there's that. Closing arguments. How am I doing on time, Dominic?
You're good. You're at 40 minutes right now.
Oh, we're doing all right.
Yep.
We're doing okay. Why do I got so many tabs open? Here, let me close this real quick. All right. Where did I leave off? So closing arguments. Again, I don't have a full transcript of what the closing arguments were, but these were the strengths and weaknesses as they have been conveyed by persons in the courtroom. The prosecution's closing argument. Let's talk about their strengths. The prosecutor, Mr. McClelland, has been described as a skilled storyteller, which is important. I would not underscore the ability of an attorney to go forth and present an effective closing argument by virtue of telling a story. I'll tell you what, when I was learning trial advocacy, when I was trying my first dozen cases or so, in preparation for presenting to a jury, it is so telling the differences between how a prosecutor presents a case and a defense attorney presents a case. Most of the time, prosecutors seem to be pigeonholed into this concrete box. They have to be within the box, no veering from the box. One of the biggest criticisms that I got when I was working for the DA was I'm way too loose with the way that I present, with the way that I talk, with the way that I do closing arguments, with the way that I do this, with the way I do that. They wanted me to button it up. They wanted me to present like an accountant, which I can never do. I'm not that guy. And for that reason, I could not work for the prosecutor's office. I tend to be less buttoned up and more akin to trying to relate to a jury. I don't like to be confined in this box, especially not when I'm defending the freedom of one of my clients. I like to appeal to common sense. I like to appeal to humanity. I like to try to step away from the judgment of the judgment hammer and try to appeal to common sense. Clarence Darrow is often regarded as probably the greatest trial attorney that ever was. They're talking about him. He's been dead for like over 100 years, but they still talk about his presentation of evidence, his closing arguments, the way that he told. He never lost a case. He would take the cases that nobody wanted to take, and he would find a way to spin it and get his clients acquitted or get them to avoid the death penalty. There's many famous cases on Clarence Darrow. There's not very much footage of him actually orating, but by all accounts, he was this guy. And when he would give his closing remarks, he had this like long, greasy hair. And back 100 years ago, I mean, they would do things a little bit different. Nowadays, they give you like maybe an hour to present your closing arguments. Back then, if you wanted to take all day, you could take all day. It would not prevent you. So we'd go on this whole list of, so you want to convict my clients. They've been convicted. They've done a terrible thing. They don't deserve to die. If you want to accuse them of murder, then what you have to do is you have to go back into their childhood, and you have to understand that these two young boys grew up in an orphanage. They were beaten every day, whether right or wrong, brutally and freely, constantly subjected to taunts and insults and insecurities. And, you know, if you want to say that these boys murdered this boy, then murdered these victims, then everybody murdered these victims, because we're all a village and we're all responsible for raising our children. And these children, if you would have put them in another household, they might be running for office. They might be going to an Ivy League school. They might be doing this or that. The only crime that these boys really committed, aside from the atrocities that they've already admitted to, is the fact that they got a bad deck of cards. And he would take this and we'd go for hours and hours and hours. And in a case where everybody thought, I'm talking about a very obvious trial right now, he would take these cases and where nobody thought it could be done, he would spare their lives. He was really good that way. He was not an attractive man. He came across sloppy, and his suits often didn't fit. He sweated a lot. His hair would like run down his face, drenched in sweat and grease and whatever else. But he was believable, and juries trusted him. And he spoke with a measure of humanity that oftentimes the states were not allowed to do. I don't think that DAs on average are necessarily bad at storytelling. I just think that they're confined to a box, constantly scrutinized, and their defense and their the way that they litigate cases, it comes out as a certain way. Now, McClelland in this matter presented as a skilled storyteller, capable of presenting a compelling narrative to the jury, which is unusual for prosecutors. But he did. He was effective in his use of visual aids. He employed a PowerPoint presentation, which enhanced certain points that he had, obviously. He attempted to link his closing arguments back to promises and points made during his opening statement. And they seem to have done a decent job of doing that, at least. In other words, in openings, you always tell the jury that, look, I promise you. You might not say I promise, but look, the evidence is going to show X, Y, and Z. And if on closing arguments, you're able to see that, look, we went through 20 days of trial. I told you on day one that you're going to see X, Y, and Z. And God damn it, there's X, there's Y, and there's Z. And if you have X and Y and Z, then that effing guy is guilty. He killed those little girls. And it's incumbent on all of you to make sure that they obtain justice. So good on him. I guess the weakness would have been specificity in linking to their opening statements. He tried to make the case. But it looks like it fell flat. Strictly because of lack of specificity. And when you have a lack of specificity, that's usually because a lack of sufficient evidence. And then where you have a lack of sufficient evidence, you usually have plenty of room for reasonable doubts. There was an over-reliance, some feel, namely Andrea Burkhart, on the storytelling aspect without sufficient explanation of the obvious holes that were present in the case. And that is dangerous. And look, it's one thing to be a great storyteller, but if you're trying to convict somebody beyond a reasonable doubt, and all you have is the storytelling, and you're not able to tie up a lot of the loose ends, and you got to do your entire case in chief and a rebuttal and your closing argument, and now we're here. And you know that the jury has questions and you can't fill in the gaps, man. You shouldn't have much hopes of gaining a conviction in the case. It had been expressed, there was disappointment in McClelland's rebuttal. It was characterized as weak and lacking in substance. He failed to effectively counterpunch, capitalize on potential weaknesses in the defense's closing. He missed the mark. And all in all, I don't know what grade people would give him in the courtroom, but it looks like he meant well, but it might just not have been enough because there was significant weaknesses in his case that he couldn't fix. On to the defense's closing arguments. They had Mr. Rosie. It said that he effectively structured his closing argument around several key themes aimed at instilling reasonable doubt, namely the broken timeline, the mishandled ballistics. Remember that? Interesting that the ballistics exam just kind of became like this afterthought as trial kind of pressed forward. False confessions, significance of digital forensic data. They focused on all of that doubt. There was an effective explanation of why the doubt exists. Unlike the prosecution, it's been indicated that Mr. Rosie, for providing compelling reasons to the jury to have doubts about the state's case, his attempt to do that seems to have been effective. He highlighted again the specific inconsistencies, unanswered questions, as you do, unexplored possibilities. I don't know how far he could have gotten into that without getting into third-party culpability evidence, and so I'd imagine there was probably a couple of objections to that. It seems by the majority of observers that he presented a more reasoned and persuasive argument for reasonable doubt than the prosecution did for conviction. There was an emphasis on this idea that the prosecution relied heavily on shady tactics, namely the Reed technique, namely withholding evidence, namely a lot of things. There's some indication that the defense, when they highlighted the lack of strong evidence, that it may, according to their perception, have resonated with several of the jurors. Now, the weaknesses would have been there was organizational issues. They, despite identifying strong themes, Mr. Rosie's closing often suffered from organizational problems. In his defense, that's usually what happens when you plan your closing arguments and you expect to be able to get certain evidence in, i.e. third-party culpability, i.e. being able to get into some of these other investigative witnesses that you weren't allowed to do because it was only going to be about third-party culpability. That tends to leave you with a fragmented closing argument. And if your defense was dependent on getting in some of that evidence, then sometimes that's what happens. It is a symptom of a case where he thought he was going to be able to get in evidence and it just didn't come to pass. There was an over-reliance on tone over substance. And again, similar to the critique of the state, it's always a risk if you're going to make these theatrical splashes. Look, I'm sure all of you, because you're watching this show, have watched trials on movies, and you see these compelling arguments to the judge, and it always looks good, and it's always, it's Catch a Mockingbird, it's always Matthew McConaughey, it's always, think of whoever your favorite fictional movie attorney is. They look good. Maybe they're crying, maybe there's tears, maybe they're pounding on the desk, maybe they're shedding tears. The problem is when you try to manufacture that, it could fall flat. If it's not genuine, people typically pick up on it right away, such as AI. Nowadays, that seems to be the main critique of AI. It's soulless. They relied on it, and, I'd imagine that, I don't know if they were doing it on purpose or if they were just genuinely upset. It seems like they had a rough trial. They were fighting not just the state, but the jury and the judge and the judge's restrictions. But there's been suggestion that Mr. Rosie might have fallen into this trap, sometimes letting his emotions get the best of him, potentially undermining the persuasiveness of the points that he was trying to make. It's been criticized that the defense's concluding remarks came dangerously close to advocating for jury nullification, which is a big no-no. If you're not familiar with that, it's basically just telling the jury, I don't care what the evidence is. You guys have the right to do whatever you want. If you guys want to vote guilt because you think it's the right thing to do, then do that. And if he's veering close to that, basically arguing for jury nullification, well, you can't do that. It's not been suggested that he did argue that, it's just he got close. Urging the jury to acquit regardless of guilt due to the treatment that Alan endured in prison, which I don't think he needed to go there. Just say, look, Alan didn't do it. We cannot continue to rely on these archaic methods of torture and psychological torture using the Reed technique to secure these bullshit confessions. It's a story as old as our justice system that law enforcement, in an effort to appease the victims and perhaps the general public's need for a bad guy, a fall guy, that we resort to these tactics to secure these false confessions that any one of you could fall victim to at any point in time in your lives. And so that was a critique. As far as the jurors' responses to that, it was indicated the jury took very few notes during closing arguments, which is not uncommon. They've already seen all the evidence. They just want to hear it from the attorneys. Sum this up for me. They're finished with the taking of the notes. It was indicated it was difficult to gauge their level of engagement. Neither side appeared to have hit a home run. Burkhart said that nobody just knocked it out of the park. They gave closing arguments. And look, sometimes it happens. Trial is exhausting. Trial is so exhausting. And so you might have had these ideas of what your closing arguments were going to look like at the beginning of trial or when you're prepping for the trial. But the reality of it is you're sitting there, you're exhausted. And maybe the evidence didn't come out the way that you'd hoped. And so now, it just kind of is what it is. I wanted to talk a little bit about the defense's strategy being restricted. I mean, there was the pretrial motions that were denied. Certainly, I've talked about that. But this third-party culprit defense being excluded is a little flabbergasting to me. Even if there's not a smoking gun connection to some other witness, the fact that you're not allowing a defense attorney to go into it just puts the entire trial. Why not just let it in? If there's even some indicator that there may have been because of, whatever the reason, the white van, for example, let it in. Let it be an issue for the jury to decide. Err on the side of caution. There is not much prejudice. Well, you're going to say it's prejudicial to the state, sure. But the danger of that is it's also really prejudicial to the defense. When the main theory of your defense is that Richard Allen is not the guy, it was somebody else, obviously, and you're not allowed to present any evidence that indicates as such. Like, for example, there were other leads that should have been followed up on, and there just simply weren't. The defense's attempts to introduce evidence, elicit testimony related to alternate suspects. We talked about that. We talked about the white van. We talked about Brad Weber, where that was met with objections and restrictions from the judge. The defense was asked to make offers of proof for some of the witnesses that they wanted to call, including Kevin Murphy and Jerry Holman. They were going to provide testimony relevant to alternate suspects. And the judge said, no, fuck you. Not doing it. Not doing it. Not doing it. I don't know what the judge's rationale was. But there's been implications that the judge might have required a higher standard of proof, which to me speaks in the face of the vast majority of case law that I'm familiar with when it comes to third-party culprits. So there's that. Where was I at with this? All right. So that's it. That was a closing argument. So I'm going to talk about the strengths of the state as it appears to me, and the strengths of the defense's case and what I think is going to happen. So obviously the state relies heavily on this confession by Richard Allen. Una, thank you so much for gifting 5 Tilted Lawyer memberships to unsuspecting folks out there. I hope you enjoy it. What's up, Pam? It's good to see you in here. I ain't seen Pam in here in forever. And so I'm really apologetic, guys. I haven't really been watching these the comments. Let me get to some of these before I forget. Pam, thank you so much for gifting 20 Tilted Lawyer memberships to various people out there. You are the best. She is my moderator extraordinaire. I haven't seen her in a while. It's really good to see you, Pam. I feel like I haven't seen you in forever, other than in the Discord for various things, various other things. And she's all, what did I do? Sarcasm has been a member for 2 months. She says, welcome to the Tilted Lawyer family. All just smash the like and subscribe. In her famous Pam voice. We haven't done a poker night in a long time. Angel, thank you so much for gifting 5 Tilted Lawyer memberships to other folks. What's up, Lauren Nighty? It's so good to see you in here, man. I feel like I haven't talked to you in forever. I haven't got a wayward late night drunk text from her in a long time. I miss you, Lauren. Threatening to teabag my dad or something. Angel with the 5. Una, I got that one in there. Julie O, thank you so much for the 5. Says Zachariah Anderson was denied third-party defense and no evidence, but convicted. Total injustice to deny a defense. I couldn't agree more. If the job of the defense is to present reasonable doubt, if you're not allowed to offer evidence or ideas of other suspects, what are you supposed to do? What are you supposed to do? Yeah, it's a problem, but it's not just a problem because of the fairness of the trial. It's just, I don't know what you guys think about Richard Allen and his guilt or innocence. Hey, Dominic, could you put up a poll?
Yeah.
Put up a poll. I want to see, based on at least my audience, who everybody thinks is guilty or innocent. Oh, Pam, I missed you too. Thank you so much for the 10. By the way, I know that you're going through a lot, man. All the prayers in the world I'm sending over your way. What's up, Bruce? Laura sends me all the drunk texts now. I'm kind of jealous. What the fuck? Lauren, that's bullshit. I'm totally kidding. She says, but I have been very sober as of late. Oh, you and I both.
You want me to put a poll for guilty or innocent?
Yeah, guilty or innocent as to Richard Allen as I go through some of these strengths and weaknesses through my notes. All right. So obviously the confession, that was a strength. You got a guy that on multiple times said he's the guy that did it. Seminal fluid. While it was unable to find male DNA, there was a presence of seminal fluid around the crime scene or at the crime scene. It suggests possible sexual assault. I don't know how much of a strength that is because you couldn't tie it to anybody. If you found that, and the fact that there's no identifying DNA seems problematic. There was blood stain pattern analysis. There was a blood stain pattern analyst that believes that Libby's hand and arm were on the F tree at about 4 feet high, which could place her at the scene during the attack, which is consistent with the state's theory that both Libby and Abby were killed at the crime scene. Of course, there was witness testimony. There were some witnesses that point to Richard Allen, but not even really, because the testimony seems to have been inconsistent, and they couldn't even identify him while he was sitting there in court. Now, weaknesses, there's a lot. Lack of physical evidence. There's lack of DNA. The DNA that was found was of an unidentified female. Maybe one of the children's moms, maybe the actual killer, I don't know, but it wasn't a Richard Allen. And if there was a sexual assault, I think that a jury would expect to find some DNA evidence there. It wasn't there. The reliability of the confessions were problematic. Obviously, the defense argument being that Allen's confessions were unreliable due to his deteriorated mental states. Obviously, I think that the jury got to see, by way of video, the signs of mental distress and instability while in prison. Problematic. The judge excluding evidence related to potential third-party suspects, I think, leaves this case unnecessarily subject to appeal. And while that's probably more of a defense or a strength for the defense, I am tabbing it as a weakness for the state insofar as, even if this is a conviction, that's a very easy appealable issue. That and the judge's impartiality, where, it seems to me, and it's not always the case, that you get multiple attorneys, people in the know, people that are familiar with what's going on in the proceedings. Shout out to the high heavens that, hey, something's up with this judge. It seems like things are a little unfair. That speaks to potentially additional appellate issues. So, strengths of the case. for the defense. Allen's mental state. I don't think that it has been even denied that there was an acute deterioration of Richard Allen's mental state as he sat in maximum security prison. And I don't think that there is much doubt that it probably affected how he gave his confessions, just like it affected how he communicated with his wife, just like it affected how he behaved in prison, just like it affected a lot of different things. There is serious doubt cast on the timeline. At best, we have a broken timeline. We don't even have a time of death for these young girls. It would have been at some point, at some time, the video was taken to the day, to the time that they were found the very next day. We don't even know when they died. We don't even know where they died. It's problematic. The defense relied on digital forensics, particularly from the cell phones, to support their arguments, challenging the prosecution's narrative. Insofar as, based on the digital forensics, we can't even point to Richard Allen as the guy. If we're going to talk about weaknesses, obviously the lack of an alternative suspect is problematic. The judge's rulings in this trial, not on appeal, but in this trial, I feel must have encumbered their ability to present their case. And I think that it probably affected their closing arguments, and it probably affected a lot of things. They had limited time because of the number of sidebars and objections that they had to argue to just try to present a coherent case. And whenever you have one side that is constantly being objected to, and those objections are being sustained, and one side that is constantly being ruled against, as it has occurred in this case with the defense, you can't ignore how much that affects a jury's perception of the defense legal team. Does it affect them enough to lose them the case? I don't know. So, in a nutshell, that is the case. Hey, Pam, thanks again for the 10. Do I think he's guilty? Do I think he's guilty? Personally? Personally, no, I don't. I don't. I got suspicions that go well beyond this trial. I have suspicions about the way that this was investigated. I got suspicions about the way that it appears that they rushed to charge Richard Allen and the timing of certain individuals that were up for re-election at the time. I got severe questions about some of the other evidence that wasn't allowed to be investigated, or just purposefully wasn't investigated because they wanted to get this confession out of Richard Allen. I have a lot of questions about the Odin group. Now, look, interestingly, when I first covered this a few months ago, or whenever it was, there was a lot of people from the Odin group, religion, club, I don't know how I would describe it, but from Odinist, self-described Odinist, that said, look, we're not a cult. We're a legitimate religious organization. We're full of good people. And then there was others that said otherwise. I have questions about it, man. I got questions about why there were people with symbols on their uniforms that were being allowed to be in the same space as Richard Allen, that were correctional officers that were sitting there in the courtroom with him, that were interrogating him, that were around his place of employment where he lived. I just got questions, man. The confessions, I was so ready to convict Richard Allen. If I was sitting on the jury, all the prosecution would have had it done is point to one fact that Richard Allen knew that nobody knew. And they couldn't. And they didn't. Their answer to that question would have been the white van. But people have known about the white van for years, going all the way back to when the crimes actually happened. And so, honestly, I don't know if he killed him or not. I don't. But if you're asking my professional opinion about whether or not there's enough reasonable doubt here, oh, yes, there's mountains of reasonable doubts. I would be shocked if this wound up in a conviction. And if it did end up in a conviction, I would have even more questions than I have now. That's my take on it.
All right, so the poll ended 72 votes, 81% voted innocent, 18% voted guilty.
71, say it again?
82 to 18.
Bruce says that the poll should have had not guilty instead of innocent. Yeah, Dominic. Stupid ass. Not guilty or guilty. I'm Ochidoro. I have no idea how to pronounce it. Says, I couldn't stay interested. I got too used to cameras in the courtroom. Not sure what that's even referring to. Angel is over here having other alternate conversations. Says, hey, General T, you obviously made it there safe. You still married? I don't know what that's about, but we're about to be doing Family Law After Dark. We're actually 24 minutes over what I anticipated doing. Folks, that is my take so far on Family Law After Dark. No, on the Delphi trial. The Delphi trial. I'm sorry. I got questions. I personally think the guy's going to be acquitted. I don't think that we're going to get a verdict today. I think they're going to come back on Monday and probably ask for additional evidence if they haven't done that already. I think that they might tell the judge that they're in a deadlock, or they might just come back with an acquittal. But I think that the longer this goes on, the more you could expect that this is not going to end in the conviction, however it ends. That's my opinion. We'll see. When a verdict is rendered, I will have I will cover it and share my thoughts and opinions. Hopefully, we'll get some interviews from the trial attorneys that tried the case, and we will see. Yeah, they got a 6-day work week over there, Lisa. So they, Jesus, I hope they don't come back on Saturday. I will not be ready. I'll have to make myself ready, I guess. We'll make it happen. Folks, I'm going to do Family Law After Dark. If you haven't already found the link, Dominic, could you drop the link for me? Hey, Bruce, you're invited, obviously. Brad, you're invited, obviously. Lauren, you're invited, obviously. Schnitzel should be in there with us. I'm also going to be joined by an additional guest, and we're going to have a good time talking about some crazy family law stuff. I love you all. Oh, Una, thank you so much for the 70s czar. This case right now is not justice for Abby and Libby. No, this isn't. This is anything but justice for Abby and Libby. And if anything, I'm upset at the way that this case was handled. They deserved a competent investigation and a competent case to be put on by the state, and I don't think that they've gotten it. And even if they get a conviction in this case, I'm not sure that they got the right guy. I just don't know. I don't know. Folks, I will see you guys in Family Law After Dark. I love you all. Have a wonderful weekend. Stay safe out there. Bye-bye. All right.